Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where we help good people regain control of their future when charged with a crime. In this video, I want to talk to you about a common question that we hear a lot, and it's unfortunately a case that we see a decent amount of coming from potential clients and ultimately clients of the firm, whereby someone is charged with murder when they have committed a DUI or alleged to have committed a DUI and an accident results and someone loses their life. And a lot of times the first instinct is, well, how can I be charged with murder? I didn't mean to kill anybody. I certainly, this was an accident. This was a tragedy. Why am I being prosecuted under the same statute as someone who intentionally tries to kill someone? More often than not, we see it prosecuted that way. And it's a case in California called People v. Watson, Watson. And the general theory behind it is that you had some experience in your life before the accident that basically states that you should have known better, that you were made aware of the alcohol and driving and how that could affect, could die because of it, and you disregarded that risk. Similar type logic behind a second-degree murder conviction, where you're facing 15 years to life if convicted, whether by a plea or whether if convicted at trial. A lot of times they rely on a prior DUI or wet reckless conviction when you're given what's known as the Watson advisal. In San Diego, it's sort of like a canary yellow DUI addendum form, and it's literally number one on that form on the second page when they start numbering them. And it says, being under the influence of alcohol or drugs is inherently dangerous to human life. In the event you operate a motor vehicle and someone is killed, you can and likely will be charged with second-degree murder. So a DUI or a wet reckless, you're given that Watson advisal. If you're in court, you're given it by the judge. If you're not in court and your attorney appears for you, you have to initial that as part of the plea form. And that is rehashed over and over again as you make your way through probation. So you see people where, they go to a Mothers Against Drunk Driving meeting, they go to the DUI first conviction program, whether that's 3 months or 9 months, or if you have multiple DUIs within a 10-year period in California, 18 months. And over again, you hear about how drinking and driving could lead to death if someone is injured in a car accident. So that's the basis that they work off of, they being the prosecutor. But a lot of times they'll do it even on cases where you don't have a prior DUI or wet reckless conviction. What they'll do is they'll talk about, well, you took this education course, you took this military training on alcohol abuse and substance abuse and driving. And, admittedly, my concern as a criminal defense attorney and someone who's been arrested for a DUI related offense in their past is that even though I was never convicted when I was arrested in 2004, and even though I've certainly never been charged since, and certainly since I've been an attorney since 2007, is under that same thinking, why can't they go after attorneys, specifically criminal defense attorneys, on the theory being you're aware of the risk, you do this for a living, you've represented hundreds and hundreds of DUI defendants, people accused of committing a DUI. This Watson advisal hundreds of times, and there's documents in the court files of every client you've represented, and you still disregarded that risk. You were aware of the risk. You regurgitated that Watson advisal hundreds of times. You disregarded the risk, and now someone lost their life. So why can't they come after someone like me or anyone at my firm or anybody who does criminal defense at a decent level and a decent volume over the years under that same theory? So really we need to be wary as criminal defense attorneys, but as anyone out there, is that if there's anything in your past that they want to hang on to, that district attorney or prosecutor wants to hang on to say you were aware of that risk beyond common sense, beyond, hey, drinking and driving is not something you should be doing, certainly not above or at or above the legal. To be mindful of that. And the worst thing you can do, if the worst has happened, whether you're drinking or not, and you're informed that someone has passed away, you are under no obligation to answer all these questions about, hey, do you remember, being told the Watson advisal? Do you remember your attorney telling you that? Do you remember going to that Mothers Against Drunk Driving meeting? You went, right? You completed that class. You're going to get all these questions. And the best thing to do is just politely decline to answer them. Politely decline to answer any questions. I'd like a lawyer. That's it. Because what happens is a lot of times, just like in any other case in DUIs, whether it's a misdemeanor DUI or the most serious second degree murder type is DUIs, a lot of times individuals, because they're so scared, because they're so inexperienced with the system, because they think telling the police what they want to hear is going to help them, they're going to go and talk about, yeah, I remember that. Yeah, I remember that. I remember that class. That was me. All that stuff. These are factors that the prosecution needs to really lay out there and prove. So don't do your job for them. I mean, the safest thing you can do, obviously, is make sure you don't drive after consuming alcohol. Make sure you drink and drive responsibly. Okay. But if you're past that point, and God forbid someone's killed, you have to be smart. You have to protect your interests, and you have to seek the advice of a quality, locally experienced criminal defense attorney or criminal defense law firm before even considering making any statements about anything, given the situation, given the gravity of what you're facing, which is an indeterminate life sentence, which means that if you get sentenced to 15 years to life, you don't know if or when you will ever get out of prison. So the stakes cannot be any higher. Make sure you're smart. If you or a loved one are charged with DUI, particularly DUI with murder under that Watson theory, feel free to give my firm a call so we can walk you through the process, make you understand what the options you have, and help you to a decision that best protects your freedom, your future, and your family and your livelihood moving forward. 619-295-3555. Again, 619-295-3555.